section. Now, access to justice. While this is a constitutional right to all citizens, the practical aspect of it is heavily dependent on resources and knowledge. There have been claims that the justice system is rigged against the poor and only favoring the rich and the influential. Tonight, we focus on the nitty-gritties of law and the fundamental information Kenyans need to know about the judicial system. Joining me for the discussion is Morara Omoke, an advocate of the High Court. Thank you so much, Wakili, for joining us for this discussion.
Thank you for the invitation.
Right, now starting off the discussion, there have been claims that the criminal justice system, not only in Kenya, is rigged against the poor and seemingly favors only the rich, and as a player in the legal profession. What do you take of these allegations?
That is a perception.
Mm-hmm.
But if you study it more carefully, you will realize that you may need to look at data,
right,
and do a mathematical and even a scientific study.
Mm-hmm.
And you will find that from analyzing, that conclusion may not necessarily be correct.
Right.
The reason being that crimes, if you look at crime, though it's not a legal classification, but if you look at crime, you can see it in two ways, that there is what you could call white-collar crime, mm-hmm, and blue-collar crime. So white-collar crime, generally the kind of crime that is committed by people who are of maybe in the middle class and in the lower social class.
Mm-hmm.
And then there is the white-collar crime, again committed by, this one particularly in the middle class and the rich. Mm-hmm. It doesn't mean that someone who is poor cannot commit a crime that is associated with the rich,
right,
or the other way around, but you can see it that way. So it means that some types of crimes will have a larger number of people committing them, mm-hmm, than others, and as a result, of course, you'll find that some types of crime that are seen as petty, mm-hmm, like burglary, that they are committed by people who are not well off in the society. Mm-hmm. So, of course, when the law is swinging into action, the people who will be found to have committed the crime might belong to a particular social class. Mm-hmm. While when it comes to other serious crimes that can be classified as white collar, like corruption, mm-hmm, and stealing of public funds, tax evasion, that the kind of people that commit that kind of a crime, they belong to the upper class. Mm-hmm. So again, you'll find a lot of them being arrested and being charged for that reason. But when you analyze crimes, you'll find that these different crimes are committed by different groups of people. The law is blind to your social class, mm-hmm, when it comes to holding you accountable. But of course, other factors may play out, which may favor someone who is seen to be rich, mm-hmm, and disfavor the one who is poor, if we use those two words. Mm-hmm. And the factors will arise, like ability to hire a lawyer, for instance, to defend you in a criminal court.
Right.
So if I'm not well off, I'll not prioritize that. I will probably defend myself and not do it very well, and end up losing my case. Not because the law or the court was unfair to me, but just based on, because the law decides the case based on the facts before it, mm-hmm, and the law, mm-hmm, and how the defense in a particular case carried on their job. So if I was defending myself and I don't have the skills, I may not defend myself very well. But one who is well off may appoint a lawyer, and even more than one lawyer, to defend them. Right. And because of that, they may have better chances, mm-hmm, of surviving the prosecution. Mm-hmm. So in the end, it might happen that both of them had some criminal liability, but one of them survives, because when it comes to crime, the standard of proving in a court is what you call, you look at, the standard is that you prove a crime beyond reasonable doubt. That's what is required of government, right, through the Director of Public Prosecutions, to prove a crime beyond reasonable doubt, not beyond all doubt, but, mm-hmm, reasonable doubt. So in a particular case, because the defense was so strong, the court may weigh the evidence and feel that it was not meeting the standard, mm-hmm, sufficient to convict someone of a crime. So as you can see, the other factors will come in, which may favor someone who is rich, right, and disfavor, as I said, someone who is poor. Not because the system is against them, but it's just different circumstances, mm-hmm, affecting their status in society.
Right. Now, still on the same, in Kenya, there was a revision of court fees in September 2021, and of course, which sparked a lot of reactions from human rights activists in Kenya. Don't you feel the increase in the court fees probably could also have an effect in the access to justice for some Kenyans?
So here we have to distinguish when it comes to filing fees. It applies differently in different cases. So in a criminal case, if someone has been accused of a crime, their main responsibility is if the court orders you to pay cash bail, which is, it's not money you've lost, it's just to secure your attendance in court or to deposit a bond. That's all you may be required to do, and to appoint your lawyer and pay the fees for your lawyer. But when it comes to court, there's not much to pay to the courts throughout a criminal prosecution, criminal proceedings. But when it comes to a civil, now, because we classify cases broadly as criminal in nature or civil in nature. So when it comes to civil, maybe that's where someone who is not very well off may be denied an opportunity of accessing justice. And that can still happen, can even affect someone who is rich. That maybe the kind of justice system, that the kind of case they are pursuing is so expensive, and I'll give an example on that. But generally, in the broad area of civil cases, if you have if you are raising a matter touching on human rights, filing your case is generally affordable for everyone, irrespective of your social class. Where the difference arises mostly is in commercial disputes. So if you entered into a contract that is more than 1 million shillings, your filing fees is often over 75,000 shillings to file your case, which again may be affordable for most people, and still a very large number of people it could be 50-50 in society. Some, when you count from middle class going up, they'll afford it, and going below the middle class, they'll not afford it. But so for commercial cases, that's where the cost might be inhibitive. But when you talk about the revision of filing fees, actually what happened is that they made exemptions for any case that is below 1 million shillings. You don't pay anything. You file your case for nothing. And when you make other subsequent filings beyond filing your case, you pay very nominal filing fees for additional documentation. So I'll give an example where a rich person who is considered to be who is in the upper middle class may still be struggling to pursue the justice. So if you have a commercial case, a commercial transaction, say you entered into a contract with the road construction companies, say the Japanese and the Chinese who are constructing roads in our country, and they provide in the contract that whenever there's a dispute, you will pursue your dispute not through the courts but through international arbitration. So often they'll provide for International Chamber of Commerce rules and require you to arbitrate your dispute in the International Court of Arbitration in Paris. So when you look at that, if you have to do this case through a foreign system, it becomes very costly. In fact, when you look at that kind of a case, to file your dispute before the International Court of Arbitration is 500,000 shillings. That's not money that is easily affordable for most people, even those in the middle class. Then when it comes to, once your arbitrator is appointed, you need to deposit money it's a deposit of your arbitration fees. The person initiating the process, and it's a percentage of your claim, or at least about 1.5%. So if your claim was, you may find that actually if your claim was so big, you're paying millions of shillings before your case commences. That could be very inhibitive. So it means that sometimes even when you have an opportunity to choose the system to subscribe to, when it comes to a dispute, you may end up choosing a system that is even very costly, even for someone who is well off. Right. So there are so many factors that come into play.
Now, at some point, it's good you mentioned about the bail and the bonds. And what I really wish to know is that, because not all the accused, probably talking about Kenya, not all the accused can be able to afford the bail and the bond that are always probably required in some cases in courts. And now, for this case, don't you feel probably that this could be having any chances, could be having the factor of these bonds and the bails could be playing a factor in the conviction chances of the accused, because at some point you find that someone is out on a bail, and then they go and interfere with probably the evidence and the witness. Of course, we've had these cases. Don't you feel access to the bails and the bonds could also have an effect on the chances of conviction of the accused?
So the way bail operates, it's actually a constitutional right, and the Constitution is provided that an accused person has a right to bail. So what happens is when you're arrested, unless the Constitution generally provides for that, but from previous practice and even in the current other applicable rules, the courts do not automatically grant bail. They have to look at other factors. So when an accused person has been brought, they have to look at other factors. Is this an accused person who is likely to run off once they are granted bail? Have they shown, if in previous cases they were granted bail, did they respect those bail terms and attend court? Because the purpose of bail is to secure attendance in court. Also, they have to look at other factors like what you mentioned. Is this person, having been released, likely to interfere with investigations,
right,
or with the witnesses who will testify against that person? Of course, if someone, there was I believe it's sometime last year, where an accused person involved in a case was found to have come up with a plan to kill some of the witnesses. It was widely reported in the media. So the court had to withdraw the bail terms. That's what actually can happen if you do not respect the bail terms, because you are required not to interfere with the process with witnesses. So of course, if you have an accused person like that, if they were to carry out their plan and kill the witnesses, of course that would have made probably the prosecution case weaker, especially because in that particular case, that was an accused person who had already been convicted, but appealed, and the court ordered a fresh trial. The High Court ordered a fresh trial. So for that kind of a case, you can see that if they were able to kill the witness, it would have been difficult to prove the case against them.
Right.
So in terms of now the bail, we can't say that what the courts ought to do, because from my experience doing many cases, I would say that the courts have not standardized the process, the principles and the considerations. It seems that the courts are very erratic in the manner in which they determine the bail terms applicable to every case. But if I was to write a guideline, I would have said, number one, let's consider the value. If the offense relates to an offense relating to property, say stealing, let's look at the value.
Right.
If someone stole $500,000, then we can't tell them to deposit a million shillings, for instance. Maybe we shouldn't go above what was stolen, the value. If someone has killed, of course, in that case, this is someone who can run away. Maybe there's justification to require them to probably deposit a bond instead of a cash bill. Let them provide a property,
right,
of whatever value, but property that they value, or property from someone that they who can secure the attendance of that person. So I would say that maybe we need to work on the guidelines to make the system work better, so that we do not have, lack of uniformity across the different courts in the country.
Right. Now, still on the same note, actually, we have seen recently when Aisha Juma's case was postponed to give her room to do her campaigns in a gubernatorial quest. And on this case, she was, being charged for a 19 million shillings graft case, which is taxpayers' money. And, these elicited reactions from Kenyans. Of course, now other Kenyans calling upon the DPP, Nordin Haji, to take action on this case. Now, what do you feel? Was this really something honorable to postpone justice? Because there are also some people who are saying that, justice delayed is justice denied. Was it really a honorable thing to, postpone justice for her?
So in that case, I've read also in the media and also listened to a number of stories online where the people were seemingly complaining against the courts, others against the DPP. I would say, first of all, I wouldn't blame the court. I know that the magistrate who is handling the case, a great friend of mine, Martha, Mutuku, is a great judicial mind. She must have made this decision based on the material before her, because for the court, she does not decide what to do. What must have happened is that there was an application by the accused person's advocates, that's Aisha Juma's advocates, to take a break from the hearing so that she can campaign. And probably the DPP did not object, or maybe the DPP objected, but upon looking at the material before the court was satisfied that that was good reason to postpone. So postponing a hearing does not mean that the case will not proceed.
Right.
So I wouldn't say we should complain against that, because that happens in other cases also. If someone was accused and they had an examination coming up, they can ask the court to postpone the hearing and continue after the exam has been, after this person has started an examination. Or someone was traveling for medical reasons, they can also seek. So it depends on the reason, and if the court is satisfied that there's enough material placed. Of course, the election is coming up. That is in the public. It's something well known in the public.
Right.
The court having been given that reason, the court can consider it. But it doesn't mean the prosecution stops, and you can't blame also the DPP, because if the DPP objected, or if he agreed, then it's because he also considered the reasons advanced by the other side. Because you don't want to have a trial where maybe on the day of the hearing, some of the witnesses are not present. It's good to have a trial that actually continues without disruption. So this is just a break they took. It does not mean that it will make the accused person, it will reduce the chances of the DPP proving the case against the accused person.
But don't you feel probably some Kenyans going forward will also be probably borrowing from how the reprieve that Aisha Juma was given, so that when they are supposed to be convicted of a crime, probably they would also want the same treatment. They cite reason that I would want my case to be postponed for this time. And then this delays justice. Of course, the ripple effects could be having the backlogs of cases or something of that sort.
Of course, that's why the courts have to consider the reason given at the particular point in time. So if it's after the election, you cannot come and give that reason as why the hearing should not proceed. I wouldn't say that can affect that can encourage Kenyans to do that. It's your case, because actually if I was an accused person, I want the case to be heard very quickly if I'm believing that I'm innocent, so that I can be proven to be innocent. So for an accused person, it's in your best interest to have your matter expedited.
Right.
For Aisha Juma, it doesn't mean that when you seek an adjournment that will delay that will stop the justice, the wheels of justice from grinding into action. They may slow down the wheels, but they will keep grinding until the justice until the outcome of the case is determined.
Right.
And I would say, of course, again, for the Kenyans, it's upon us now, when we cast our vote in the coming election, let's not vote people that we know are probably doing things that are not appropriate, especially when you talk about public funds.
Right.
We shouldn't elect those people. That's one way of us responding. So instead of complaining about the courts have not done this, what can we do as a people? Let's not vote them.
Right.
Yes.
Now, away from that, actually, there have always been these, relevations that come out of, people who have been convicted who are already in prisons, and, cases coming out that someone was convicted, someone was imprisoned for a case they didn't commit. We've had these cases, probably someone was, framed on a case, and then it later occurs that this person was jailed, was prisoned for a case that probably they didn't commit, and of course there are evidence that they didn't commit this case. Now, on this, should we really say that it is a failure of the justice system, or the executive, or the parties that are supposed to do the investigations, who are supposed to take the blames?
Sometimes the blame is, you may not be able to blame any particular player in the justice system. Sometimes you can blame, you could blame the investigators, you might blame the DPP. But what I would say is that it's unfortunate, of course, if someone is convicted for something they did not do. But what I would say you should do if you believe you are not culpable for the offense for which you were convicted, and you know that there's evidence that was not presented, you can always apply to to have your case relooked at based on availability of no evidence. So at the time during the time when your case is ongoing, you should never keep quiet if there's information that can shed light and probably lead to a finding of not guilty. So it's also for the accused person to be diligent. Whether I have an advocate or I do not have an advocate, I should ensure that anything that can show the court that I am an innocent person I should present it to the court.
Right.
Yeah.
Now, probably because the interest of time as we're winding up, among the impediments to access to justice, lack of information has been cited, and it's probably in the public domain that most Kenyans, when they are convicted of a crime or an offense, they don't know their rights. So what are some of the nitty-gritty, the small things that someone who is convicted of a crime probably should know when they are going to the judicial system to seek justice? What are some of the nitty-gritty, the small things that they should be knowing at least that would give them an upper hand in finding justice?
So the first thing I would say, let's all abide by the law. Let's not commit crimes in respect of our social class. Secondly, whether I can afford a lawyer or not, I think is extremely important. If we're talking about crimes, it's good to understand, it's good for us to all read the Constitution and understand, especially the Bill of Rights, which has covered a lot of things that can help you to pursue your rights. Secondly, let's ensure that we read the procedure of the court. The procedure of the court is found in a law called the Criminal Procedure Code. It contains generally the procedure in the high courts and the magistrates courts in Kenya. But of course, there's other procedures that will be applied if I have a criminal case that has found its way to the Court of Appeal. So there's the procedure of the Court of Appeal found in what we call the Court of Appeal rules that covers that. So when you read those rules, they'll cover all the procedures relating to appeals arising from criminal cases in the High Court. Again, if I have a criminal case that might find its way to the Supreme Court, I should read the Supreme Court rules, also which provide the procedures in that court. Just so you understand what happens in this court just to understand, just the way if you were told to apply for an ID, you're 18 years old, you'll find out what am I to do, what is the procedure, you'll find out. So just the know-how, just getting to know what is required in those courts. Thirdly, I would say let's also understand the substantive law generally, because then that way you know what is prescribed. Because when it comes to criminal law, you cannot be charged for a crime that is not prescribed by law. It has to be prescribed in writing. So all the crimes, generally, majority of the crimes are contained in the penal code. But there are other laws also provide for criminal offenses. And maybe almost every law that you can think about has some. It says if you do ABCD, that could amount to a crime. Almost every crime every law you can think about.
And maybe on a light note, the pro bono services, are they applicable to all cases probably, or
they're actually particularly applicable in criminal cases. The court can secure an advocate to represent someone who cannot afford, and that is usually to be paid by government. So if it's good for parties to look for those services, very important. Of course, you can also approach a lawyer if you may agree, any other lawyer out there to represent a party for free. They can do it. Personally, I don't do pro bono cases unless it's something that I have considered very keenly. Generally, I do not do pro bono cases, but I can consider. Depending on the facts of the case.
All right. Thank you so much, Wakili, for dedicating your time for this discussion. Of course, we know Kenyans have learned a lot from this, and they're also now getting away from the notion that the justice system is tilted to the rich and not favoring the poor. We really appreciate, of course, your presence here.
Thank you very much.
And with that, we're taking a very short break. We shall be